Good afternoon, everybody, and welcome to Unfair Competition and Battling Information Technology Theft, an ABA antitrust section program that's been co-sponsored by the State Enforcement Committee, the Media and Technology Committee, the International Committee, and the IP Committee. My name is Ankur Kapoor. I'm a partner at Constantine Cannon here in Washington, and I'm a vice chair of the Media and Technology Committee, and I'd like to welcome everybody who's here in person and who's joining by phone to this absolutely cutting-edge program that's been put together largely through the efforts of the State Enforcement Committee. Very briefly, it, I think, touches upon not one but two cutting-edge issues in competition law, namely the use of Section 5 of the FTC Act and the so-called Little FTC Acts to combat unfair competition, but also in the industry of the many industries of manufacturing, and specifically the use of information technology to advance manufacturing into what the Wall Street Journal has recently referred as, just a couple of weeks ago, as a new industrial revolution. So this is a very timely, very important, very cutting-edge program that we're presenting for you today. I'd like to introduce the moderator of our panel, Rob McKenna. No surprise to find him on this panel, as he's been involved in numerous cutting-edge issues as a current partner at Orrick, Herrington & Sutcliffe, and also a former two-term Attorney General for the great state of Washington. Among his many, many accomplishments, Rob was the president of the National Association of Attorneys General, and among the many, many accomplishments in that role, he co-launched the IP, Intellectual Property Task Force, to combat precisely the kind of unfair competition that occurs through information technology theft, and about which we are all here today. Rob has also been at the forefront of data privacy and security protection efforts, and all the while managing a law firm of 500 attorneys at the State AG's office in Washington. So without further ado, I'll hand the mic, so to speak, over to Rob.
Well, thank you very much for the warm introduction, and thanks to Cannon Constantine for hosting us here today for this webinar. We have quite a distinguished group of panelists, and as well a distinguished group of folks in the audience who are listening by telephone and reviewing the PowerPoint slides on their computers. We want to thank the American Bar Association for working with all of us to put together this webinar on a very timely topic indeed. To discuss it today, we have three panelists who will be speaking, and I'll also make a brief presentation to discuss the problem of unfair competition arising from stolen IP and stolen IT around the world. We're going to begin by hearing from Professor Bill Kovacic, who is a professor at George Washington University Law School and is well known to many of us for his many years of service at the Federal Trade Commission. He served there as a member of the Commission from January of 2006 until October of 2011, serving as chairman of the FTC from March of 2008 to March of 2009. Less well known about Bill is the fact that he started out as a young lawyer at the FTC and served there twice on the staff, the second time serving in the role of general counsel at the FTC. Bill is known as one of the, if not the expert on the FTC Act and the work of the Federal Trade Commission. He has not only worked there and in private practice and taught these issues, he also has traveled around the world as a highly respected expert on fair competition. He's advised numerous governments around the world, dating all the way back to 1992, and is really recognized as an expert on these issues globally. So we're going to start with Professor Kovacic, and then we're going to hear from our other panelists, Emilio Veronini from the California Department of Justice, and then Tiffany Adams from the National Association of Manufacturers, and then I'll slide in between Emilio and Tiffany and talk about some of my work as Washington State Attorney General. So with that, Professor, if we could start with you. Thank you very much for being here.
Thank you very much, Rob, and thanks to the Section of Antitrust Law for the honor of participating in the program, and to our hosts here at Constantine and Cannon for giving us this wonderful facility to speak from. Section 5 of the FTC Act, as you know, has two dimensions. One deals with unfair methods of competition, the other with unfair or deceptive acts or practices. I'm going to go through how the framework on both sides of the agency's jurisdiction might be applied to the misappropriation of intellectual property and its use as a means of developing or expanding business for firms that don't pay or license to use the intellectual property properly. Without trying to define the complete framework of Section 5 or to deal with some of the more difficult questions about its broader scope or what the limiting principles might be, I think it's helpful to think about how we could apply some very basic screens in the application of the statute to decide how piracy might be treated. I think the first and broad area of consensus is that Section 5 as a distinctive theory of liability should apply to episodes of serious misconduct. And it seems to me that piracy at issue here easily clears that threshold, both with respect to the original conception of the statute, to its application in the early decades of the FTC's operations, where in many instances misappropriation of intellectual property rights featured prominently in FTC cases. That is, if we think about the fidelity of a theory of liability to original conceptions of what the statute might reach, unmistakably, privacy-anchored cases would fit squarely within the view of Congress and the early commission about what the appropriate use of the statute would be. If we asked by reference to more modern conceptions of either economics or law how we address or respond to piracy, piracy is a serious form of harm, both with respect to actual economic effects and with respect to likely economic effects. It's very difficult to imagine that it would be necessary to spend a great deal of time to establish the case that this kind of behavior is serious misconduct. The second screen we would use is whether there are plausible justifications that can be brought to bear to rationalize the misappropriation of intellectual property. And it seems here that it's hard to muster good justifications for the behavior, indeed any justifications at all. In this instance, we avoid the messy questions of whether or not there are offsetting pro-competitive justifications. It's hard, I think, in any theory of law, competition law, property law, contract law, any framework that we might apply to muster a good justification for theft. It's very difficult to conceive of how it would be useful. I'm not talking about hazy instances in which we might have disputes about whether or not a license covers a specific use. I'm dealing with a simpler scenario of an outright simple theft of the property where the user knows with certainty that a license ought to be obtained and simply chooses not to do it. In this instance, it's hard to imagine a pro-competitive or beneficial justification for the conduct in question. So the second screen that I think these cases would pass through with relative ease is the application of a justification standard. Hard to see how those exist here. The third question might be the application of other legal frameworks. And here I think there are really two questions. Is there an existing concept in legal doctrine that might conceptually cover the behavior? Second, as applied in the routine decision of cases, the routine vindication of nominal legal rights, does the existing apparatus of enforcement provide another path? If you answered yes emphatically to both of these questions, then you might ask quite properly, why would the FTC be involved? I think the challenge to the FTC to be involved might be greater, perhaps for any public institution. What about existing doctrine? Well, there's little question that virtually all systems of law across the globe treat theft as a serious offense. So it's neither jarring or surprising that the theft of intellectual property might be regarded as a serious offense. The real question then becomes, what about the mechanisms for applying it? And I think in this instance, we find the absence of effective mechanisms of oversight and implementation in the jurisdictions in which the theft takes place, as well as the relative weakness of mechanisms in North America to use alternative strategies to challenge the behavior through trade or other law that might be applied to the misappropriation of intellectual property. there's a legitimate question to ask. At what point do we look at a nominal legal framework and declare it to be inadequate or ineffective? And I think that is a legitimate point for discussion and debate, but it seems to me that in the context that we're examining now, that there's been a demonstrable failure of the nominal legal mechanisms that might be used to address this behavior. Either the public authorities in the relevant jurisdictions choose not to use them, or that companies that are victims of the conduct in other jurisdictions find it extremely difficult to vindicate their rights in the court. This is something that you would evaluate on a regular basis to see if changes have taken place to make the application of a nominal legal command effective over time. But if we ask in general, is there an effective framework for giving meaningful implementation to legal commands that forbid piracy? I think the answer, generally no, at this point is a confident no. A last hurdle to be cleared under the FTC Act, and here I think today we'll see some variation perhaps in the application of state laws. The prohibition on unfair methods of competition calls for harm to competition, some theory of competitive harm. And there it might be necessary as a matter of demonstrated anti-competitive effect or likely effect to show that the misappropriation injures rivals. That is, an apparel manufacturer that plays by the rules, pays for the rights in question, suffers a competitive disadvantage at the hands of a firm that does not. There, I think it would be adequate for FTC Act purposes to show actual or likely harm. And if we see the FTC framework as a series of interdependent elements where we demand proof or additional proof depending upon the conclusion we draw about the seriousness of the misconduct, serious misconduct, absence of justifications, hard to find them here, weakness in the nominal framework for implementation, decidedly weak, then we might be less demanding with respect to the precise quantum of actual or likely harm. For unfair deceptive acts or practices, the protected group consists of what the original FTC policy statement and the 1994 legislation that codifies it refer to as consumers. The formative FTC cases tended to focus on harm to individual end users. The famous Orchid case that dealt with pest control services, a unilateral increase in prices imposed by the service provider. In theory, individual consumers, under any well-accepted principle of contract law, could challenge that. It's a breach of contract to unilaterally increase the price. That's a fairly straightforward case. Why did the FTC intervene? Because the means available to consumers to vindicate their interests were decidedly weak. And the gap between the amount of individual harm, the benefit to the company, the cost to bring that case for an individual consumer or to join a class made in practice the vindication of those rights unlikely. But the victims were end users. So the tougher question comes up, what if the victims, the consumers, are commercial entities? The Commission has brought cases in which the victims were small businesses. The NData case, which deals with the repudiation of a previous promise with respect to IP licensing, is a famous example in which the FTC was willing to act under either an unfair method of competition theory or an unfair deceptive acts or practices theory to protect the interests of computer manufacturers. Dell, for example, being one of the major victims in the FTC's theory of liability. So the FTC certainly, through its own enforcement process, in settlements that have not directly been challenged through actual litigation, has achieved what might be called an expansion of the notion of the zone of protected interests, so that not necessary under that theory to show harm to a competitor or harm necessarily to an end user, but harm to other commercial parties has been deemed to be sufficient to establish the application of the Commission's jurisdiction. Future cases may litigate that point directly and ask whether or not commercial entities deserve protection within the FTC's conception of unfair deceptive acts or practices. That's probably the trickiest legal point going ahead. But when we look at the other screens that might be applied, seriousness of the misconduct, offsetting justifications, Effectiveness of enforcement through other collateral mechanisms for legal review. It seems to me that you get by all of those screens relatively easily here. The one issue that might be interesting for debate, if the Commission were to use its authority here, would be the last one. That is, who constitute the zone of protected interests? Whose interests are protected under unfair methods or unfair acts or deceptive practices? Thank you.
Well done. Thank you very much. We're going to turn now to Mr. Emilio Veronini, Deputy Attorney General with the Antitrust Section of the California Office of the Attorney General. Emilio has an economics degree with distinction from the University of California at Berkeley and a law degree from UCLA. He's also studied international trade and economics at the University of Bordeaux in France and was selected there in 2000 as a Salzburg Seminar Fellow, working on transnational perspectives of intellectual property and communications. Emilio is the international liaison of the National Association of Attorneys General Antitrust Task Force, previously served as vice chair of the ABA section of antitrust law, has also served as chair of the China Working Group for the ABA section of antitrust law for 2 years. He is liaison counsel and chair of the multi-state litigation group in the international price-fixing DRAM case. So he's well known to all of us from the Attorney General community, and allow me to take this opportunity to give a shout out to all of my former colleagues in the AG offices around the country, including Deputy Attorney General Tina Kondo, who I understand is listening from Seattle today. Emilio, we'll turn it over to you. Thank you for being here.
Thank you, General McKenna, and let me also say good morning to my friends and colleagues on the West Coast, and good afternoon to everyone else. And let me also thank our hosts for putting together this presentation and allowing us to have it here in Washington, D.C. So let's start off with this question. Why is intellectual property important to the states at all? And I think in answering that question, it's important not to just look at those who hold the intellectual property themselves, the property owners, but it's also important to look at the downstream industries that have to use this intellectual property in their daily activities. And so when you have companies stealing intellectual property, not paying for it in order to get a competitive advantage over their, over their competition here in the United States, it's that effect on downstream industries that concerns us in the States. So what am I talking about here when I talk about examples of intellectual property that can have an effect on downstream industries? Well, if you turn to the slide that has a map of the United States with these pretty pictures, it's more than just the pictures that you see here. So you might see the picture of the prairie dog and the windswept prairies. Well, if you think about wind turbines, for example, or solar, these are industries in which intellectual property, both on the hardware side and on the software side, is important or is becoming important. If you think about fracking, that has made states like North Dakota and Ohio and Pennsylvania incredibly rich, fracking also depends upon intellectual property as well, and people's willingness to pay for the use of intellectual property to make it a competitive exercise. Then there's Wall Street, which depends on financial software. There's Oregon with its wood products, and of course the state of Washington, which General McKenna will be talking about. So, in other words, the use of intellectual property in downstream industries concerns us in states because we want a fair competitive process where everyone is paying the license fees that are required to use intellectual property. So now to understand how the states can address downstream industry problems involving the theft of intellectual property, it's important to look at state unfair competition laws. Now, as former Chairman Kovacic pointed out, federal unfair competition laws are headquartered in Section 5 of the FTC Act. However, the states have their own baby FTC Acts, and for California, that is in Section 17200 of the California Business and Professions Act. So what are the powers of the California Attorney General under that act? Well, we can seek civil penalties, we can seek restitution, and we can seek forward-looking orders from the court that is designed to address harms to the competitive process and remedy those harms. And we can do all of this without having to show standing. which is very important. Now, what are the various uses of federal and state unfair competition law? Now, I know our audience are experienced practitioners, and you've already heard from Foreman Chairman Kovacic, so I won't bore you with the details. But essentially, you can use federal and state unfair competition laws to remedy violations of antitrust laws, to go after violations that, if completed, would be violations of antitrust laws. But there's also another use of federal and state unfair competition laws, which is broader than federal and state antitrust laws. This is what is often called a pure Section 5 case or a pure 17200 case. And essentially, we can go after unfair business practices, even if those practices are not per se a violation of antitrust law, if those practices significantly threaten or harm competition, and if there is no legitimate business justification or existing law that excuses that conduct or gives it a safe harbor. So when we talk about a practice that significantly threatens or harms competition, it's important to note that we don't have to actually show market power or a market-wide effect, such as you normally have to show to make out an antitrust violation when it's not per se. It's also important to note that the standard I discussed here comes from the California Supreme Court case of Celtec, which was a competitor versus competitor lawsuit. We in California believe that when it is not a competitor versus competitor lawsuit, that the standard's even broader than an analog to Section 5. However, for purposes of this discussion today, we'll assume that what prevails here is the Celtec standard, which is an analog to Section 5 of the FTC Act. Now, I should say that the use of state unfair competition laws to remedy violations that are not antitrust violations has not gone unnoticed. There are folks who do argue that you need to show a specific injury to consumers, such as having to pay higher prices, in order to make out a violation of state unfair competition law. However, there are others who have noted that there is no such requirement, at least as a matter of state unfair competition law. And as you've heard Foreman Chairman Kovacic point out, perhaps not as a matter of Section 5 either. And that indeed, if you have an unfair business practice that hurts market efficiency, such as the use of theft to gain a competitive advantage, that can be enough. Now, I'm going to quote the late Judge Bork here, or rather paraphrase him. But the late Judge Bork was always keen on pointing out that when you have a practice that hurts efficiency, that ends up hurting consumer welfare. And it's that kind of practice that you should go after. Now, we all remember the Microsoft case, and we could go over whether the Microsoft case did represent a violation of Section 2, the antitrust laws, or not, although California's view is on record. However, it's important to note that what the courts found was that even though the practices that Microsoft engaged in were perhaps speculative in terms of their impact on consumers, after all, how do you value, from a consumer perspective, the value of having a Netscape browser versus an Internet Explorer browser? Nonetheless, the view that was articulated by the courts, which was the late Judge Bork's view, was that this hurts efficiency and thereby hurts consumer welfare, and so that even under the antitrust laws, you could go after these practices by Microsoft. So from the viewpoint of California, we see the unfair competition laws as the use of an old 20th century law, because the unfair competition laws in California go back to the 1930s, to address these 21st century problems. And we see it being more flexible than the use of antitrust law, where a number of questions have to be answered to be able to figure out whether antitrust law can be applied to this set of circumstances or not. And if you want to know what kinds of questions you would want to ask, you can take a look at the relevant slide. So what are examples of where unfair competition law can be used to address intellectual property right abuses? Well, I'm about to talk about our piracy case. But just to give you another example, so that you all don't think that our case is an orphan or unique or we somehow made it up, take a look at the patent holdup cases, and take a look at what the FTC has filed with the ITC and others. And you'll see that this is exactly the same kind of problem. And the FTC has come up with the same kind of remedy. So with patent holdup, we all know what it is, and it is defined in my slide. But that's an example of where the FTC has used unfair competition law to address a problem that can't be remedied under the antitrust laws, yet poses a threat to competition itself. We in California believe that the pirating of software to gain a competitive advantage is a similar example. So let me turn to that. Now you can see the graphics involving the two apparel companies that we sued, Ningba Beyond and Pratibha Syntex. One of the two companies is in China and the other company is in India. Now the details of our lawsuit can be found on our website, and I provided the address for that. But let me give you at least a taste of what the basis for our assertions in that lawsuit are. So first of all, we've pointed out that what we have here is the pirating of software. This is back office software, design software, and security software, whereby these companies, Ningba Beyond and Pratibha, failed to pay license fees to be able to use this software under copyright. And as former Chairman Kovacic has pointed out, the fact that it is uncontroverted in India and China, as well as here, that you cannot use copyrighted software without paying license fees. That goes all the way back to the Berne Convention, and it is in the laws of these countries. So therefore, the pirating of this software is theft. We believe that the pirating of this software, the theft, has both short-term effects and long-term effects. And both of those are important. So short-term effects. In an industry involving low margins, not paying license fees gives apparel companies more money to hire additional employees and pay for research and development. And that money compounds on itself year after year in a low-margin industry. Long-term effects, in an industry where you can't get intellectual property protection, that industry is going to relocate elsewhere. We've all seen what we like to call now inshoring, where industries, manufacturing is coming back to American shores. And the apparel industry in Los Angeles is a great example of that, as I'm going to discuss. However, if you can't protect IP here, then that inshoring is just going to become offshoring all over again. Now, if you take a look at the next slide, you'll see some more cool graphics, at least I hope they're cool, involving the strength of the nexus to the industry. So you see here Adobe and Semitex. We could have added Microsoft and a couple of other firms as well, such as Corel. And Adobe does design software, Semitech does security software, and Microsoft is important for back office. And in a low-margin industry, you need this software to be able to effectively compete. So you see over on the right, you have American Apparel, 3 Dots, Splendid, and Gap. Well, some of these companies are American apparel companies that compete vigorously, that manufacture apparel here in the United States. So if you're Gap and you're a retailer, okay, and you depend on making sure you get the best competitive price, who are you going to go with? Are you going to go with the American companies that are paying license fees? Or are you going to go with overseas companies that can save you even a little bit of money because they're not paying for that copyrighted software and they've now got a competitive advantage? And if you turn to the next slide, it's important to emphasize the nexus here with California. And this gets to the point that I just made a little bit earlier. Los Angeles has a vibrant apparel industry. If you Google Los Angeles and apparel, you'll see what I mean. There are apparel companies in Los Angeles that compete vigorously. There is the Fashion Institute, where research into new methods of apparel is done. There is Cal State Northridge, where yet more research is being done. And you can see the high-tech future in apparel unfolding in Los Angeles. So for us here, we think that there is a very strong nexus between what these two apparel companies are doing abroad, Ningba Beyond in China and Pratibha in India, and Los Angeles, California. But they're not just the short-term effects, they're also the long-term effects. So as I said, where we see high technology now sweeping through apparel and transforming that industry, it's important to note that these unfair business practices also hinder innovation in the state of California. Because why bother to innovate if people are just going to steal what you've come up with and you can't protect it? So people often ask me, well, Emilio, this is all well and good, but we don't think of apparel as being high tech. Can you give us any examples? And I have lots, but this latest one I thought was really cool, being a Star Trek fan, so I went ahead and used it. And that's the 3D printer printing a shoe. So if you turn to that slide, you'll see a woman's shoe. I'm sorry, the image is a little bit compressed, but you can see the you can see the shoe sitting there in the 3D printer. And that's just an example, one example of many, about how apparel is being transformed by innovation here in the United States and specifically in the state of California. Now, there are a couple of other points I would like my audience to think about, because I often get asked. First of all, it's important to note that existing international treaties and laws overseas do not address these downstream effects. This is what we could call sort of a black hole in international trade and international intellectual property law. And we're filling that hole. The other point is that this lawsuit that we've brought does not violate any international treaties. We're just as willing to go after domestic companies that try to get an unfair competitive advantage in this manner as we are willing to go after foreign companies. So I'd like to finally address briefly what we're seeking by way of remedies. Civil penalties, we can get $2,500 per violation, and what a violation is very flexible under the law. On the injunctive side, we're seeking a ban on piracy. We are going to seek a bar on products entering into or transitioning through California. So as you all know in the audience, a lot of imports into the United States come through the Port of Los Angeles and the Port of Oakland. We will be seeking an order barring Ningbus products and Prodibus products from coming into our state, even through consignees and agents. And that is something we are very confident we can get through our unfair competition law. We're also going to want compliance training and audits. And finally, if we have to go this route, we'll even seek a freezing of assets. So with that, thank you, General McKenna. And if anyone has any questions, my contact information is on the slides. Thank you.
Well done, Emilio. Thank you very much. Just to drive home the point, the actions that Attorney General Harris has taken in California are not quite unprecedented, but definitely groundbreaking. And thanks to you, Emilio, and your team for the work you've been doing with General Harris on that regard. Massachusetts has also taken similar steps with a lawsuit that Attorney General Martha Coakley brought there against a seafood processor based in Thailand, where there was evidence that the company was using stolen IT to gain a competitive advantage over seafood processors in Massachusetts. Now I'm going to talk about a different matter that did not result in a lawsuit, but which resulted in changes to business practices by a fairly prominent company. This is an action that I'm very familiar with because we initiated it in 2012 while I was serving as Attorney General for the state of Washington. First, a little bit of background. The company involved is Embraer, the world's fourth largest aircraft manufacturer, domiciled in Brazil with commercial, military, and executive aircraft applications. Evidence was brought to the Attorney General's office in Washington that the company was engaged in significant and deliberate under-licensing of some of its software. In fact, there was evidence presented that while they had purchased 10 licenses for a particular program or suite of programs, they had installed those software packages 3,300 times against the purchase of 10 licenses. The loss to the Washington software vendor involved was estimated at $3.3 million, and we were also concerned about the unfair competitive advantage that not paying for software provided to Embraer vis-a-vis its aircraft manufacturing competitors like Boeing and Canada Air. There was an effort by the software vendor to obtain cooperation, and then a preliminary effort by our office to obtain Embraer's cooperation, and those efforts did not prove fruitful. Fortunately, the prior year, we had worked with the Washington State Legislature to adopt a statute on stolen or misappropriated information technology. It's codified at RCW 3.19.330.020. That's RCW 19.330.020. It states in relevant part that any person who manufactures an article or product while using stolen or misappropriated information technology is deemed to engage in an unfair act where such an article or product is sold or offered for sale in this state. So in California and Massachusetts, you have cases that have been brought under their statutes prohibiting unfair and deceptive acts and practices, or their UDAP laws. In Washington State, of course, we have the same type of UDAP statute, but in addition, we also now have RCW 19.330.020, which specifically calls out and prohibits the use of stolen or misappropriated information technology, deeming it an unfair act in each case. Now, when this information was brought to our office, we faced an initial challenge of just figuring out what we could do to enforce this law against a company where we had significant evidence that they were misappropriating information technology. Consider the limitations that we faced. First of all, there was the question of staff time. We were already quite busy in our antitrust section. Secondly, there was a little fact that this aircraft manufacturer is based in Brazil and we're based in Washington State. Third, we knew that if we needed to engage in extensive discovery, that a lot of the documents would be in Portuguese as opposed to English. Fourth, our budget could not bear a high cost or high risk because the antitrust budget in Washington State is funded on a revolving fund basis. So it's important to be able to recover costs and fees to replenish that fund when an action is taken. There's also a matter which is fairly unique to Washington State, where when the state attorney general brings an action and ends up not being successful, which fortunately rarely happens, the state of Washington can be held liable for attorney's fees. So we have to be particularly mindful that when we bring a case, it needs to be a very, very solid case to avoid or minimize that risk. Well, the easy answer, given all of those questions and all those hurdles, would have been to do nothing, to simply shrug and say, well, sorry, we'd like to help, but we don't have the resources, or the resource cost would be too high for us to help. Fortunately, we found another solution. The solution was to send a strongly worded letter to Embraer, citing the statute, citing the evidence that we had, and to put pressure on the company to do the right thing given that evidence. And to their credit, the company did take the right step. They did end up paying for the use of the unlicensed software, and that benefited the software vendor, Microsoft, as well as competing aircraft manufacturers in North America, including Boeing, Canada Air, and others. So this example is given today as part of this webinar because it shows that there are other avenues available to state AGs as enforcers of their UDAP statutes, short of bringing a lawsuit. And in this case, we felt that the effect of obtaining this settlement or this compliance showed that there is a sentinel effect, a deterrent effect from taking action when appropriate evidence is provided. And the slides that we're presenting to you today that are available to you by email are based on slides prepared by the Chief Deputy for the Attorney General's Office of Washington, Brian Moran, which he presented to the National Association of Attorneys General in Boston last week. With that presentation, I'd like to turn to Tiffany Adams, Vice President with the National Association of Manufacturers. Tiffany has been with the National Association of Manufacturers, or NAM, since 1992. She's the primary staff contact, as is the Vice President for Public Affairs there, for NAM's National Public Affairs Steering Committee, a group of 150 leading corporate public affairs and government relations executives from NAM's largest member companies who bolster the association's grassroots efforts. Tiffany, I guess if you had to sum it up, has primary responsibility for NAM's relationships with its grassroots members all across the United States. She did her undergraduate work at Temple University, has become a nationally recognized expert on manufacturing issues, working with her members. And Tiffany, we're just delighted you could be here to provide kind of the big picture view of why these issues are important to your members.
Rob, thank you, and I want to thank my fellow panelists and the audience that's listening in on this webcast. It's interesting. I've been sitting here hearing the very technical and legal side of this issue, and from a manufacturing standpoint, there's lots of folks who think that this may not affect the average manufacturer, but indeed it does. Software piracy, software theft. How do I put this in a way that is clear? It hinders the competitive advantage of manufacturers based in the United States. And we're a group of folks who play hard. We work hard, we follow the rules, and to have other companies stealing our own intellectual property and stealing the opportunity for our companies to continue forward is a huge issue. The NAM got involved with this issue very simply because American manufacturers want to remain competitive. We have folks, we represent 12,000 member companies, from the smallest of manufacturers to the largest of manufacturers. This issue affects us all. We decided to become very active with the National Alliance for Jobs and Innovation. That's the NAJI coalition that is really looking to spearhead this issue, and we're dedicated to it. We have companies who are focused in on the coalition and focused in on trying to help state attorneys generals, folks like my fellow panelists, to get the issue across and to stop this. We've got to address this. We cannot wait any longer. And I'm quite frankly anxious to talk to some of the folks on the phone and get some questions to see how you all see this issue moving forward. Rob, you gave a great example using Embraer, and I've been looking through Emilio's slides this entire time. And as a non-attorney, one of the only non-attorneys on the panel, and in particularly our audience is pretty much all attorneys, I want to hear from you all the action plan. What's the action plan? Where do you see this happening? We've talked about it for years. We've looked at it for years. But is this the year that we finally move things forward? Is it a legal fix? Is it a legislative fix? What are the next steps? I know the nation's manufacturers are prepared to speak out. We've been working with a number of companies and quite frankly, working to educate companies on how this issue affects them. There are some who think it may be off to the side, but there are some who see exactly how it hinders their competitiveness. And we want to continue working with those folks. We want to continue educating the nation's manufacturers, and we want to continue educating the nation's attorneys general, because we need to see a push.
Well said. Well said. Thank you very, very much, Tiffany. We're going to move to questions now, and as those of you who are listening, and the phones are ringing now, operators are standing by to take your calls, and we have a lovely pen set for the first 10 callers. But I'm going to begin with a question that I'd like to pose to Tiffany, just to tease out the issues with respect to NAM. One question I had for you, Tiffany, is whether there's a difference, you think, in how important this issue is of stolen IT and the competitive disadvantages that creates. How important it is to large manufacturers versus small manufacturers. Is it more or less important depending on the size of the company?
It's absolutely equal. There's no difference with the smallest of manufacturers, and I think the smallest manufacturer at the NAM has exactly 2 employees. And then on the flip side of that, we have manufacturing companies that have hundreds of thousands of employees. And this issue is equally as important. We are looking at folks who are using this technology and this software to build their business. It's operating the machines. It's connecting them with their supplier base. It's connecting them with their customers and their employees. It is important throughout the business. It's important for their manufacturing processes. And, you know, there's absolutely, just to put a finer point on it, no distinction. This is important to the mom and pop shop and the global manufacturer.
Well, a good example of that would be Marlin Steel in
Absolutely.
Baltimore, a wire basket maker active with NAM. Its CEO, Drew Greenblatt, is the chairman of the board of the National Alliance for Jobs and Innovation, which you mentioned. We refer to it as NAJI, N-A-J-I. And it's recently incorporated as a 501c6 trade association. Mr. Greenblatt's involved with it precisely because his small company is seeing its competition use all kinds of unfair competition involving stolen IT to compete unfairly with his company. So the companies are taking action, and thanks to NAM for being involved, and thanks to NAJI for the same. I'd like to move now to see if we have questions that have come in from folks who are listening from their offices. And if we do have any questions, we'll turn to the first one.
All right, operator, we're ready.
And at this time, if you'd like to ask a question, please press *1 on your telephone keypad. That's *1 for any questions or comments. We'll pause for a moment to compile a Q&A roster.
And we have people who are here in the audience in the room, so if any of you have questions, please pop your hand up so I can see them, and then I'll just repeat the question for the benefit of the audience. So please don't be shy about that.
So I have one question.
Yes, Ankur.
I will ask it of Emilio and you as well, Rob, in your capacity as AG. When bringing these actions against companies abroad, what kinds of issues have you had, if any, and I assume there have been some, in obtaining jurisdiction over these companies, in obtaining evidence from these companies, taking discovery? Now, I think this really goes to the point that Tiffany was making. As a practical matter, what are we going to do, how are we going to do it, and what problems have you had and how have you solved them?
Amelia, please go ahead, and then I'll speak to a little bit to Massachusetts and Washington.
Well, obviously, the process for serving companies abroad that don't have an agent for service here in the United States is a lengthy one under the Hague Convention. The Hague Convention lays down processes to follow for those states that are signatories, and in our case, both China and India are signatories. We've gone through that process in another case that precedes this one, and we're going through that process in this case. We're very confident that we can establish jurisdiction here, just as we've been confident that we could establish it in other cases. There are multiple means of establishing jurisdiction, both based on the volume of commerce and that's involved with these companies versus the United States, and also based on other ties that these companies may have with the United States as well, and specifically with California.
In Massachusetts, when you look at the case that the Attorney General there brought against a Thai seafood processor, we had products coming into Massachusetts from Thailand, and that was judged to be sufficient to establish jurisdiction. In Washington State, we never really reached that question because we based our letter to Embraer on evidence brought to us by the software vendor, and since we didn't actually get to the step of filing a lawsuit, we didn't worry so much about those particular legal issues, and just focused instead on the fact that we had pretty clear evidence that was never really denied when we finally got down to it, and were able to persuade the company to do the right thing. And you know, it's interesting because there you had a very prominent aircraft manufacturer, as I mentioned in my presentation. They're the fourth largest aircraft maker in the world, and I think they had some legitimate concern for reputational harm that would result if they fought this. And one thing about AGs is that in addition to having the power to issue subpoenas and file lawsuits, the AGs also command the bully pulpit. And when you're talking about companies that are concerned about their reputation in the American markets, you have some leverage there. So that can result in perhaps quicker action in some cases. Now, you could also have companies overseas where there's evidence that they're using stolen IT for a competitive advantage, who frankly couldn't give a hoot for their reputation in the United States. So you might have a tougher problem there. And in between those two types of companies, you can have companies that are pretty active in their home countries. I recall, Emilio, that in the case of California, the case that California brought, that at least one of the manufacturers involved went to their national government and went to their trade association in their own country complaining about the lawsuit and seeking some sort of assistance to try to fend it off. And last I heard, they'd been unsuccessful in that effort. So it can become kind of interesting how the company overseas can react. But as Emilio pointed out, these laws and this type of case could be brought against a company based in the United States just as readily, in fact more easily, than a company overseas. And the way the AGs have been approaching these cases is that if they found evidence of stolen IT being used by an American manufacturer to gain a competitive advantage over its competitors, they would be ready to take action against those companies as well. Do we have any questions from folks who are listening over the telephone?
Yes, sir.
Go ahead.
You do have one question from Jeff Bartholomew.
Yes, software piracy is obviously a form of copyright infringement. I'm wondering if anyone on the panel is aware of any situations in which state action was brought for patent infringement based on state unfair competition laws, or whether the Patent Act, Federal Patent Act, preempts such state action.
On the federal question, I'll turn to Bill to see if he has any thoughts on federal preemption, although it's a Patent Act question, not an FTC Act question. And I'll tell you from my own part, I'm not aware of any AGs so far bringing an unfair practices and acts case based on patent infringement, although it's an intriguing idea and one that I think would be interesting to study.
I don't know, Rob. As much as being an academic, I would like to assert knowledge here, which is the habit of the practice. I'm not sure what the effect on a state enforcement action would be of the federal regime.
Although I did notice Bill taking notes, so don't be surprised if this shows up on his next final exam for any of you students who are listening.
No, on final exams, I don't know the answers they do.
Exactly. Very good. Well, I'm sorry we don't have a better answer for you on the federal question, but as I said, unless Emilio or anyone listening from the AG offices knows differently, I'm not aware of an AG office bringing a case on its under its state consumer protection laws for patent infringement.
I'm not aware of a case that's been brought to date based on patent infringement by state AGs. That doesn't mean that there isn't a case out there. One important point I would like to add is that our case depends upon the effect of these practices on downstream industry. It's not a copyright analog.
Right.
So issues of copyright preemption, for example, don't come into play because we're focused on the effects on the downstream industry, and the copyright violation here, in our view, based on our investigation, is an established fact. So whether a patent case would have similar downstream effects such that you wouldn't have to get into the issues of preemption, perhaps, I don't know. I'll leave that to my fellow attorneys general to find a case that they feel is appropriate to bring, and then we may all be back here discussing that case.
Yeah, very good. Excellent. Thank you. Are there any other questions from folks who are on the phone?
No, sir, not at this time.
Okay, questions from folks here in the audience? Yes.
I have one question for both Bill Kvasik and Emilio Veronini about federal-state cooperation. Perhaps, Emilio, you can talk about any interactions you've had with the Federal Trade Commission in your investigation of this issue, and Bill, maybe you have thoughts about the role of federal-state collaboration, in particular the letter from the National Association of Attorneys General that General McKenna mentioned earlier was addressed to the FTC requesting, I guess, joint action in this area.
I can't talk about federal-state cooperation with respect to this case or with respect to any specific investigation that we do. That's a confidential matter. All I can say in general is that our relationship with both federal agencies is very good. I'd like to think that our cooperation is very high. That's what I've seen in the cases and investigations that I do, speaking as a general matter, so I've been very pleased with it. I found it to be very helpful. I hope my federal counterparts have likewise. So with that, I think that's all I can say at this time in response to that question.
One way to see this issue, along with others, is what should be and what is the national competition policy of the United States. And to answer that question effectively, because of the distribution of authority among public decision makers, in principle would require the formulation of a coherent program among the public agencies. That is, what you might like to see every year is that the public agencies regard their role as being partners in a joint venture, and that the joint venture partners would meet on a regular basis, as a joint venture would in a business setting, to decide what our priorities are for the year ahead. This would involve something more than ad hoc cooperation on individual matters. You would imagine, as a matter of form, that you would have the relevant decision makers, the Department of Justice Antitrust Division, the Federal Trade Commission, the state attorneys generals, at least at some point in the year, sit down collectively and say, what do we mean to accomplish in the coming year? What is the appropriate use of our authority, given different comparative strengths, different capabilities? What are the top 5 things on our list? And to whom might we assign principal responsibility for effectuating those aims? Do we have some agreement on what the 5 would be? Not just for the coming year, but for the years ahead. And if we ask, what is the process by which that happens every year? It does not exist. That is, you have discussion, you have conversations in different settings, but if we ask, what is the equivalent to what the Europeans have, something called the European Competition Network that joins the Directorate for Competition in Brussels with its member states in regular intensive discussions about cooperation, and increasingly about the establishment of a comprehensive European strategy for competition law. Where does that exist in the United States? Where's the domestic competition network? It does not exist. And I think, Greg, your question points to the potential gains that might be realized if there were a more elaborate process by which the relevant decision makers would sit down and say, where can we move the needle of economic performance ahead? And this set of issues might well belong on it. And a far more detailed discussion among the different decision makers about what the unfairness components of national and state authority bring to the picture. What is the relationship between the existing competition laws, the relationship between the existing competition laws and tort law, copyright, our questioner's observation about the link between federal patent law and the capacity of state instrumentalities to bring suits that deal with piracy-related issues. The opportunity to have a discussion that maps out the range of jurisdictional options, the range of substantive capabilities, and then says, as a collection of public decision makers, how do we go ahead? Now, some of this happens already. That is, there are discussions along this point, but I would suggest that your question points to a respect in which the institutional framework for decision making in the United States is not nearly as good as it could be. And to the extent that you'd like to develop a more comprehensive approach that also, by the way, marshals resources more effectively to dealing with these specific concerns, we have a few rivers to cross to get there.
Let me address the letter that you referred to, Greg, and Bill, I'd like to ask you about it. As I recall, we sent that letter in about November of 2011. If I'm right about that, it arrived just after you left the FTC.
That was a golden age.
We missed our opportunity, clearly, the window. You could almost hear it slamming shut as you walked out the door. But no, in seriousness, we wrote a letter. There were 2 of us who put that letter together, Attorney General Jim Hood of Mississippi and myself, the reason being that we were the co-founders of the Intellectual Property Task Force at the National Association of AGs. And because we had more than 2/3 of the AGs sign it, it became official NAG policy or policy statement. And for any of you who are interested in reading that letter, it is found at the National Association of AG's website, nag.org. It should be posted there with other sign-on letters from 2011. And the letter basically asked the FTC to look at stolen IT as a matter of unfair practices, unfair trade practices under the FTC Act Section 5, in hopes that the FTC might seriously consider bringing an action under federal law of the type now that we've seen brought by some of the states. Do you have any thoughts about the likelihood that the FTC could bring some such action under FTC Act Section 5 in the future?
I think it is feasible. I think that there are some interesting questions of policy and technical analysis that would go into framing such a case. When you look at the DNA of the FTC and go back to its origins, as we mentioned earlier, business torts were a key component of the initial framework. The expectation that the FTC would establish national norms of business conduct by using this distinctive capability. And the idea that and informing vision for how to do that would come from well-established concepts of business torts was a central assumption on which the agency was created. So I think from a number of perspectives, that is going back to, again, original purposes, actual capabilities, this is the kind of matter that might well lend itself to the application of the FTC's authority. And you're familiar with the broader debate about Section 5. That is, what is the high ground for the FTC to pursue? Not just to use Section 5 of the FTC Act as an end in itself, activity for its own sake is not an appropriate pursuit of public policy. Yet the use of this distinctive capacity to resolve legal concerns that escape appropriate resolution by other mechanisms is exactly in the conceptual sweet spot of what the Commission should be doing. And it seems to me that this is a very promising area for discussion and consideration by the agency. Again, serious misconduct, yes. Offsetting rationales, hard to find them. With a variety of effects that Emilio described before and that Tiffany referred to as well. I guess what interests me in part is that when you did the letter, were there conversations with the FTC before you wrote the letter?
I don't think that there were. I think we were focused on using state law at that time. If I were to do it over again, I probably would pursue that avenue as well.
I think in the framework I have in mind, that would be part of the conversation that happens before the group does the letter. And I think for purposes of thinking of how, again, if we envision this federal-state constellation of decision makers as fellow venturers, they're partners in a common enterprise. Both with respect to the federal statutes, but also to the distinctive supplemental capabilities that come from state law, that greater efforts to realize the full potential inherent in that framework would be a good way to take on this kind of issue too. And to talk about, as you said, I mean, the tough question that was posed before, how do you get jurisdiction? How do you get discovery? What happens if Embraer, notwithstanding all the concerns you mentioned, say, thank you for your interest in competition law? No. And as you mentioned, they have very good reasons to be concerned about the North American market and the whole RJET sector in which they're so important. But that's where you start engaging the national authorities that have some other instruments now that help address these kinds of issues. That in particular, where you have an overlay of foreign policy, you have an overlay of trade policy. I think by engaging this larger collection of resources, when you come to the tougher cases, you have a better platform for getting answers for a very serious economic problem.
Makes sense. Very good. Do we have other questions from folks who are listening by phone?
Yes, sir. Your next question is from Victor Stoneman.
Go ahead, Victor.
Thank you. This is Vic Doman with the Tennessee Attorney General's office, and as a member of the State Enforcement Committee, I do appreciate all the panelists today. I did want to make two statements, I guess, related to today's discussion. Although it did not quite make the panel today, there was also another settlement reached probably at 3 a.m. Eastern Time this morning in which a Thai manufacturer of tires reached a settlement with parties related to the theft of software in the production of tires that have been imported to the United States. In relation to that settlement, I will mention that the Tennessee Attorney General's office did send several letters to the Thai Attorney General in an effort to help that process along, and we felt that the import of tires through the use of pirated software did hurt manufacturing of those tires here in the United States, and so we sent that letter along. But I also wanted to add one comment. There was a discussion today about not only the leverage AGs can apply, but also whether federal agencies should be involved. One thing that I would recommend to anyone who is involved with these matters is to also reach out to perhaps the embassies in the countries in which you are perhaps asking for assistance or help. That is one key that I think as antitrust enforcers we don't always consider. You know, we always think about the DOJ and the FTC, but don't forget that there are people on the ground in those countries who may be able to provide insight and, in fact, provide some advice as well. So that was really all I had to say, just really comments and addition to the panel today. So once again, thank you all for appearing today, and that's really all I have. Thank you.
Vic, thank you. That's it's great to hear, and congratulations to the Tennessee Attorney General's office for that success. You mentioned that the office sent several letters to the tire manufacturer, and that you got the result that way. Were there any federal agencies or authorities involved in that process that you're allowed to comment on?
None that I'm actually allowed to comment on.
Okay.
But yes, I would say, as I said, I gave some advice about what others may consider in the future, and so I would think about that if, in fact, you do approach agencies in other countries. Obviously, we did approach the Thai Attorney General, and you know, different countries have different cultures, and so you may want to consider how to do that. I think it's important to think about it rather than just the typical American approach. So think about who you're trying to get in touch with and the best way to do it under perhaps their thoughts and culture.
Very good. Thank you. That's most helpful, and thanks for the breaking news here on our webinar. That's just perfect timing. Thank you very much.
I would just offer a further reason that having the collaboration can be useful is that sometimes to our foreign counterparts, the full array of U.S. authorities can be a bit bewildering. Today it's a visit from one entity, then another, and another, and another, and there can be a little bit of simply confusion about who am I talking to? Are you all working on the same problem? Are you working on a different problem? The deeper collaborative, cooperative effort helps provide some clarity to our foreign counterparts as well.
I think that's exactly right. Other questions from folks who are on the phone?
No, sir, not at this time.
Okay, from people here in the room? Mr. McCurdy?
Bill, you just mentioned how bewildering the U.S. legal system and the different enforcers can be to foreign audiences. As one of the founders and really forces behind the growth of the International Competition Network, I wonder if you see there might be a role for NAG or some of the leading state AG's offices in this country to participate to help explain to the international audience, some of the intricacies of our system and some of the enforcement priorities that these offices have.
I think an issue for consideration, although ICN only consists of what might be called national authorities, that's part of its charter. A notable number of ICN members have significant competition policy functions dedicated to political subdivisions. That is, regions, what we would say are the equivalent of our states. And I think an important issue in the background is what is the relationship between these other public resources and competition policy decision makers to the national regime. That is, there's a tendency in all of these national settings, as Greg knows, as so many do, that we talk about U.S. competition law. Well, what is that? Who makes that? That is, when you simply take into account that even before going to the frameworks that Rob and Emilio were so instrumental in applying during Rob's tenure as AG, and now during Emilio's tenure, before we even go to the state-specific legislation, states, of course, have broad authority in many areas to enforce federal legislation. So to talk about the enforcement of U.S. competition law, if we just take the Sherman Act and Clayton Act as two, you can't answer that question without considering the role of the state. So, to my view, an interesting issue for state, for the members of the ICN, for the members of the United Nations Committee on Trade and Development, and for the Organization for Economic Cooperation and Development is how do you engage? What is your relationship with political subdivisions within your larger boundaries? How do you work with them? To what extent are your responsibilities dissimilar? And to the extent, again, that you should envision yourself as being part of a genuine collaboration, how do you decide who does what? How do you try and pull policymaking in directions for the entire nation or entity in directions that are worthwhile? So I think a very useful focus of discussion in these other networks would be the role of your states. You could imagine a panel in which you have representatives from one of the U.S. states, one of the lender within the Republic of Germany, where you take important decision makers, and you would have a panel and say, this is what we do, and how at a time when each agency is being pressed to do more with less, how does the network of decision makers inside each jurisdiction do its work? Among other things, on this narrow point of cooperation, that when you go to the relevant government agency, that there is not the appearance to them that you speak with many voices, that there's some common vocabulary, even that you just explain to them. I'm from the California AG's office. I'm from the state of Washington. I'm from Massachusetts. You might get other visits, but to the extent that we can mass our efforts in a somewhat more coordinated way for your benefit, we'll do that too.
You're good. Okay.
Oh, I'm sorry, I couldn't resist asking the professor a question, turning the tables a little bit. So, Professor,
You know the response is to say, well, what do you think?
And you might want to use the mic
Or-
too, just for the benefit of the.
Or, of course, we'll get to that later.
So what do you think of Commissioner Wright's policy statement last week on the use and the limits of Section 5, and both generally and how it would apply to the kinds of issues that you've been discussing today?
First, for the purpose of moving the discussion within the FTC towards the development of a common set of standards, I think it's a great start. In its 100-year history, almost 100-year history, the Federal Trade Commission has never issued a statement, a policy statement, that says this is what we see Section 5 to be with respect to unfair methods of competition. It's done that for unfairness. It's done that for deception. It's done that for merger policy. It's done that for competitor collaboration, but not for this ingredient of its authority that is integral to what it does. In my business in the university, to pass the course, you have to turn in a paper. Doesn't always have to be a great paper, but you have to turn in a paper. The FTC for this 100-year-long course has gotten incomplete because it's never written the paper. As a starting point for thinking about where we go ahead. So bravo to Commissioner Wright for stimulating that debate and setting things ahead. I think if we look at a couple of core elements of his theory, a couple of respects in which, again, the notion of how the misappropriation of IP fits within a possible conception of what Section 5 might involve. If you're taking the clearest cases, that is not more problematic cases, but the clearest cases, what's in the bullseye? Serious misconduct, no offsetting justifications, and the incapacity of other legal regimes to deal with it effectively, 1, 2, 3. I think that's what we've been talking about today. So, and I believe that Commissioner Wright had in mind, in particular, harmful conduct, no justifications. I believe if we just take those two critical screens that he applies, it seems to me that this fits.
Good. Other questions from anyone on the phone?
No, sir, not at this time.
Okay, from folks here in the room?
Two in the back there.
Okay, thank you. Yes, please, Professor Priest. And I'm going to repeat your question since you don't have a mic. Unless you'd like to hand him the mic, then we could save that step. Thank you, sir.
Yeah, so I just have a quick question about remedies, and maybe you could clarify a few things or talk about talk about remedies. So first of all, I'm wondering, particularly with regard to the state unfair competition laws, what kind of remedies are available? Are there private remedies for injured competitors? Is it fines, what other kinds of sanctions, injunctions, what other kinds of sanctions are available. And then a second but related question is on conflict of laws. So in other words, taking, for example, the Tennessee case that we just heard about, where a tire manufacturer was held or settled the case, I guess, was held liable. Could you, for example, bring the same case or a similar case against the same tire manufacturer in California? And are there issues with conflict of laws or, sort of double remedies in this kind of situation? So.
Okay, so let's talk about remedies first and then conflict of laws second. And so I was asked about what would be the remedies for private plaintiffs. So let's start off with a key difference under our state unfair competition law. A key difference between the California Attorney General's office and private plaintiffs is that private plaintiffs have to show standing. And standing is a specific concept under the unfair competition law. That's injury to money or property. And so if you were to look at this particular case that we brought and ask yourself whether private plaintiffs could bring it, well, if, let's say, a copyright holder were to bring it, there would be questions of preemption. If a downstream industry participant were to bring it, the answer is that they could, but they're still going to have to meet the standing requirement. A further difference is that a California Attorney General's office can get civil penalties. A private plaintiff cannot. Now, a private plaintiff can get restitution, but restitution would be difficult to establish under state law without getting into the particulars of that. So for a variety of reasons, we believe the California Attorney General's office is the party best positioned to be able to bring these kind of lawsuits under our unfair competition law. As we stand in the place of the state as a whole and the general economy as a whole, as well as the competitive process. So let me talk about conflict of laws for a moment here. And to get to conflict of laws, you first have to ask yourself, does a state have jurisdiction? We believe both based on the volume of commerce and possibly certain other contacts I don't want to get into, the answer is yes, California has jurisdiction. With respect to the tire case, I would have to look at those tires that were coming into the state and whether they were competing with companies in the state in some meaningful way before I could determine whether there was a jurisdictional nexus, similar to what we see here with respect to apparel and California. But let's just assume that issue doesn't exist and move on to conflict of laws. If California has jurisdiction, then, as most of you in the audience I'm sure know, it's California's standard or test for conflict of laws that would apply. That test is the substantial government interest test. And I won't get into all the details here, and I can't speak to how that test would work in a hypothetical tires case because I know nothing about that. That question would be better addressed to my colleague in Tennessee. But in terms of California and apparel, I don't see a problem under the conflict of laws analysis, and I'm sure neither does my general, or we wouldn't have filed the case. And the reason for that is simple. This is theft. It's theft in violation of copyright, and it's theft under Chinese law, it's theft under Indian law, it's theft under American law, and it's theft under international treaties, i.e. the Berne Convention. The question here is, what do we do about its downstream effects? So we don't believe that any government would have a legitimate interest, that would be the standard here, in saying that it's okay for their industries to use theft to be able to compete against their competitors, especially with such a well-established set of norms that go against that. So for those reasons, we don't believe that there's a conflict of laws problem here. I hope I've addressed your question, Professor.
Other questions? Yes.
First, what wonderful discussion. I'm curious about the classification of defendants and the jurisdictional issues that were raised earlier. It seems simple enough if you have a domestic defendant that's knowingly engaged in the use of stolen IP or IT and has property in the United States. I don't see any jurisdictional problem. I see huge problems with foreign defendants, and I think the answer that you can go forward under the Hague Convention is hopeful at best. It's a complicated, expensive process without a long history of success, but at least it's a methodology. But I wanted to focus on a third class of defendants, which would be domestic, unwitting beneficiaries of stolen IP or IT. And my question is, and it's really for the whole panel, I wonder what you think the public tolerance is for initiating a legal proceeding against a domestic defendant that's the beneficiary of stolen IT, but is unwitting, doesn't realize that the products that they're selling have benefited from the sale of a stolen technology or stolen intellectual property.
Bill, you want to start?
Go ahead.
Well, I would make one note. I think that's part of what NAJI is focused on, is educating the public, educating these various manufacturers and the unwitting defendant on exactly what the implications are for IP theft. You know, there's an expectation on the part of manufacturers that when a competitor isn't playing by the rules, that their government will take action, whether it's from the state side or the federal side. And I think that, you know, there's the rare case out there where folks just don't know that they're doing this. But that's the job, I think, of NAJI and quite frankly, the National Association of Manufacturers to educate them. So on the technical side, I'll leave it to my fellow panelists. But again, there is an expectation that we will not allow theft to be the norm.
So let me elaborate a little bit on that. So when we're talking about our apparel case, there obviously there are retailers in this country who import substantial volumes of these apparel products from the companies that we've gone after. And there's no doubt in my mind, speaking just for myself, that these companies, whether it's Forever 21, Walmart, Gap, Target, you name it, they're not tracking, you know, oh, okay, our clothes come from this apparel manufacturer and we figured out they're stealing IP and so we got to stop. There's no doubt in my mind they don't know. And it's just the way the supply chain works. They just want to get their goods, they want to get it cheap, that's all they really care about. So part of the process is education, and that's what Tiffany here, that's her function, and they're doing a great job with that. But we believe that there's no point in going after people who don't know. Really, I mean, they're not even part of the competitive process. So they're looking at American apparel manufacturers and overseas, and they're making a judgment just based on, you know, costs and quality, because that's all they know, that's all they have time to look at. So our job is to make sure that there's a fair competitive process so that when retailers go in to make that call, they're making it based on the fact that there's a fair competitive process that's in existence, that they know that, you know, whatever they're getting at the best price and the best quality wasn't obtained by an unfair competitive advantage. So to focus on them is really not to focus on where the problem is. And we prefer, our general prefers this very strongly, that we focus on where the problem is. We try to fix that problem. And if we can't settle, you know, then in our view, getting an order that bars these goods from coming into the country will, from a perspective of California, will fix the problem, because then we can now make a statement, now we know, and now retailers will know that these clothes, the competitive advantage is due to theft. And that will help retailers and help folks make an informed judgment. And that's what our general is looking for here.
I wonder, Andy, in the larger set of issues that firms face in dealing with their supply chain now, where for a single shirt, the buttons are made one place, the design comes from another, the fabric comes from another, the assembly comes from another, the pieces literally can cross many jurisdictions. I wonder if there will be another setting in which the question of the responsibility for the purchaser to police that supply chain will be resolved. Of course, not simply with respect to intellectual property, labor standards, health, safety, environmental policy. That is the broader question of what responsibility the end commercial purchaser has to certify compliance with certain standards going all the way back to the supply source itself, and maybe reaching into specific major input suppliers for its supplier would be. I wonder if that will that take place as part of a larger framework of discussions about trade policy? Is that something that ultimately is best suited to a broader discussion, because it seems to me that it also raises this question, as you know, has emerged in so many other settings as well. And does that become the forum in which we ultimately get an answer to your question?
I'd like to add that, companies that rely on overseas suppliers can also play a role here. Many of the larger companies already require their suppliers to certify that they're following their native country's own laws, whether those are environmental laws, labor standards, or IP protection standards in some cases. So large American companies that, and even smaller companies that buy heavily overseas can also play a positive role here to protect the supply chain. And even if it may not be directly relevant to them, it could be very, very relevant to American companies who they also rely upon as suppliers. So I'd like to take this opportunity to call on them to be mindful and to enforce the rules that they themselves have imposed through contract, because that strikes me as a very useful avenue for protecting American companies from unfair competition.
So as Rob mentioned earlier, the public authorities have a great capacity through their advocacy, their reporting activities, their publicity work, to not only raise concern among commercial participants, but among the larger public about what's taking place. And you see a bit of a market response now. There are increasing number of vendors who acquire their goods from a far-flung collection of suppliers who increasingly will try to identify for you where it came from. That is, you can look at an RFID chip and it will tell you here's where the cotton came from that was woven into the shirt that you're wearing now. Indeed, in some instances, here is the specific producer whose land it came from now. And it's a reaction, I think, to the concern that, again, your very useful question poses, which is what's the duty of the vendor to ensure fidelity to different national, international legal commands. And I think we see a public sentiment now as a result of this raising of awareness that demands of suppliers more and more. I'd like to have some idea of where you buy it and how they treat their laborers, how they behave within this larger context of legal commands.
Well, we've come to the end of our 90 minutes for this webinar. I'd like to thank our panelists for their participation and their excellent presentations. Thanks to each of the three of you. Many thanks to the law firm Constantine Cannon here in Washington, D.C. for hosting us here today. And of course, thanks to the antitrust section of the American Bar Association for working with us to organize this panel. Hope you all have enjoyed it who've been listening, and for those of you who have a chance to watch this when it's posted on video by the ABA, thank you for your participation as well. Take care.
Thanks, Rob.
Thank you, General.